Court is calling 2022 CR 11724, State of Texas versus Jordan Luke Robbins. Can I have parties announced for the record for the state,
Raymond Saldana.
for the defense?
John Foley from Mr. Robbins, Your Honor.
All right. And are you Mr. Robbins?
Yes, sir.
All right, you may be seated. We're here today, and the reason why we're here today is for sentencing. The court has received the PSI report. Any objections to the PSI report, defense?
No, Your Honor.
State, any objection to the PSI report?
No objection.
And the court is also in receipt of the defense's motion for factors for consideration. Those letters that are included, the court noted that I previously received letters through the mail from some of the letters, from some of the persons who are presented in your factors of consideration. What the court did was the court made sure that the coordinator emailed copies of that letter to both the state and the defense, so there will be no ex parte. All right, are there any witnesses for sentencing, or is it just going to be argument?
My understanding, Judge, is that it's just going to be argument considering that sentencing was to a jury. I think
Yes.
we're just here to discuss whether or not the motion to stack is going to be granted.
All right, and state, are you requesting stacking?
Yes, we are.
Right. And why?
Would you like the argument now, Judge?
Yes.
So the Texas legislator almost never do cases get stacked. Most cases are normally or usually run concurrently, but the Texas legislator purposely allowed the sentences to be stacked for these kinds of cases because of how serious they are. The code specifically allows the sentences for indecency with a child contact to be running consecutively. And in this case, the arguments that I made to the jury of the sentencing should be applicable in this hearing as well. And that is in this particular case, it's the number of times that the defendant committed the acts. There are 3 counts that were alleged in the indictment, but just like how I told the jury, just because there's 3 counts, that doesn't necessarily mean that it was only 3 times. It was 3 different instances that happened multiple times. And as Arabella stated, it happened in the old house and it also happened in the new house. She talked about the instance where she was 5 years old and she felt his private part on her private part over the clothes when he was squeezing her. She describes it as being uncomfortable, hard, and it hurt. And she even had to go to the bathroom to pee, and that's how she discovered that there was blood in her underwear, which she stated and she testified that never has bled from there before. The second instance that she talked about, or count 2, was in the new house in the shower, where the defendant used a washcloth and was poking her in a manner that hurt her. And she demonstrated to the jury the motion that he used, which was like playing a piano. Alexandra, which is Arabella's mom, testified that that motion itself indicated it involved foreplay when she used to be with the defendant. And of course, Arabella also testified about the living room incident where she was sitting on a small couch on his lap and he felt his private on her, and she described it again as hard, it hurt, and it was uncomfortable. Shorts were, at the beginning when he sat down on him, his shorts were not wet, but when she got up, she noticed that his shorts were wet and she had to go to the bathroom to dry up with toilet paper. And of course, this happened multiple times. So the number of instances I think is important to consider. We also have to consider the age of the child. She was 6 years old. It happened when she was 5 through 7 years old. Most of the instances happened when she was 6 years old. So I think that's also taken into consideration. But more importantly, Judge, I think we also have to consider the profound effect that this abuse has had on her. We had multiple witnesses that have testified to the effect that this has had on Arabella. We had her pediatrician who testified that the signs and the symptoms of anxiety and PTSD were extreme. Actually, that was Kelly Bernstein. That was actually her counselor. And her pediatrician, Dr. Stanford, talked about how the behaviors that Arabella displayed were extremely concerning, especially the ones in 2022. We even had testimony about Arabella self-harming herself and blaming her as to why she felt guilty because she wished she could have disclosed this sooner. So given the seriousness of the profound effect, the age of the child, and the fact that the defendant committed these acts multiple times,
Excuse me just 1 second. Jackets are not allowed in the courtroom. Sure. And just so both parties are aware, the court set through the evidence, so the court remembers the evidence in the testimony. All right, you may continue.
Thank you, Judge. Defense did file I guess, a notice or a factors for consideration for the court. And they bring us some data from the Texas Department of DPS and I think it's the sexual registration, the registration data that we have for the state. And I think they were able to narrow down some cases of indecency with a child contact, and they were able to divide them into 3 different categories. I think category 1 to 5, if the defendants received 2 to 5 years in TDC. The second category, if the defendant received more than 5 years TDC, and then the third category, if the defendant received more than 10 years TDC. And the argument from what I see is because the majority of the indecency cases per se, they've been given between 2 and 5 years, then the motion to stack should not be granted because it would be either unreasonable or outside the norm. But I think defense in this motion fails to or ignores that most cases, every case is different based on facts, based on the age of the child, based on the effect that this has on the child, based on the defendant. Every case is different and we cannot rely based on data. But more importantly, none of this information talks about whether these cases actually went to trial. Most of the cases today tend to plea. In fact, I would even say 95% of the cases tend to resolve through a plea bargain. And I don't think a defendant would ever agree to have his sentences or his counts to be stacked. There's very little evidence to show that any of these cases went to trial. And in this case went to trial. We went in front of the grand jury, in front of the jury. We presented the evidence. The jury found the defendant guilty. So because the legislator has allowed for this specifically in the statute for us to utilize and to stack because of these kinds of cases, I think the court should grant this motion. And we ask the court to grant the motion to stack and sentence Mr. Robbins to 18 years TDC.
All right, so State, you mentioned other instances, but in your indictment, you didn't file other instances. So the question becomes, in the court's mind, the other instances that you are speaking of, I can't read the jury's mind. I don't know if the other instances, the jury believe them beyond a reasonable doubt or not. But the court will note that the court did hear the complainant's testimony in the case. Defense.
Thank you, Your Honor. I won't belabor going through all the facts again, as Your Honor sat through this trial and knows well what the evidence looked like. I think at this point, what we're trying to decide is what kind of sentence is appropriate to serve justice and is not unduly harsh and punitive. The jury heard all the evidence. They came back with the sentence of 6 years. They were in the best place at that time to consider that issue. They could have gone for a higher sentence on each one of these counts, Judge. What I would like you to consider, we're not belittling or minimizing the seriousness of the offense or the impact this might have had on the child. What we would like you to consider at this point is Mr. Robbins' character throughout these proceedings. You have seen attached 27 letters of support. You also saw Mr. Jordan as he came to court throughout the pendency of this case. He's got no criminal history other than a case that was dismissed. A 6-year sentence is something that would be enough to serve justice, but no higher than necessary. He will take that opportunity to improve his life. As you can see from all these letters of support, he has family support when he's released that will help him transition back into the community. There's no indication that there were any other factors that would indicate that he is some sort of predator or had any other allegations of this sort in his history. For that, Your Honor, I think that this 6 years is more than adequate to punish this defendant. Any more than that, I think would be unduly harsh, Your Honor.
All right. The court will note that these types of cases are very difficult to prove. And they're very difficult to prove because many times what ends up happening is there are delayed outcries. And then usually there is no medical documentation of injuries because it's delayed outcry. I also remember the questions the jury had about this case. And when I say the questions the jury had, I mean the questions that they sent out for parties to answer. And I understand that it is within the court's purview to decide conditions of probation, to decide whether counts should be stacked or not. When I was a young attorney, judges would say, well, what specifically do you think the jury would want? Would they want it stacked or not stacked? And I would always argue to them, as a prosecutor, that that's within your purview. And of course, when I was a defense attorney, I would say, Judge, yeah, you're right. So I understand what each party wants. I've listened to the testimony. I'm aware of your client's history based upon what has been presented to me throughout the trial. I, of course, looked at the witnesses as they testified. I looked at the defendant as he testified and as he sat in court. With this sentence, the defendant has a label, and that's a label of sex offender, and it's a lifetime registration. And lifetime registration, as both parties knows, that in of itself is extremely limiting where he can go, limiting who he can and cannot have contact, limiting where he can live. This is what the court is going to do. And the court is basing its decision on the evidence that I've received, the evidence that I've heard. In some cases, you have cases where people confess. And then in that case, it's easy to determine whether or not somebody should be stacked or not. Sometimes it's a matter of, do I think this person is somebody who will reoffend again? Then it's easier to decide whether to stack or not. And part of that is listening to the defendant's testimony to try to gauge. I don't have a crystal ball to try to gauge to see if someone will reoffend or not. It's very hard to be in this position where you're trying to make a decision on whether a case should be stacked or not. You have to weigh the complainant, you have to weigh the defendant. It's not just for the court to consider the complainant without considering the defendant as well. If it were for the court to just say, I'm strictly going by the complainant, I'm not considering the defendant is not a part of this, then that would be an easy decision to make. But that's not where we are here. So this is what the court is going to do. Counts 1, counts 2, count 3 will be run concurrently. There's to be Chapter 62 registration. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
I have not signed it.
All right, if you will sign it, please. I think you previously did sign it.
Yes, you've signed it. We
It's
went
this
over it.
document here. Excuse me, do you have the trial court certification? Was that given to him? Yes, it is.
It's the same copy.
He's looking at it right now, Judge.
All right. So did you review that with your attorneys and sign it? All right, you do have a right to appeal because this is a jury trial. However, because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right. My understanding is there's also a motion that has been filed by appellate counsel.
Your Honor, we do have victim impact statement. Would you like
Yes,
to
I
hear that?
understand that. Yes. My understanding is there also is a motion that has been filed by appellate counsel.
Yes,
That will
Your
have to be heard in the afternoon because we have a jury trial.
Yes, Your
All right,
Honor.
with that being said, we can go off record. My understanding there is going to be victim impact. I require that everybody is respectful of everybody. So there's someone who will speak to you. They may tell you how they feel about this. Just internalize it, okay? All right, who will it be?
It'll be Mom.
All right.
Yeah, do you have the?
Oh, he's already been sentenced to 6 years by the jury from last time, and I've sentenced him 6 years.
Are we ready, Judge?
Yes. Norma, did you call Charles Bart? Yeah. All right, if you all will switch out, and we're gonna take up R.C. Curtis.
Give this back to the prosecution. You keep the reports.
No, he's not done. So 1:30. Yes,
Thank you.
thank you, you're welcome. Oh, well, I say 1:30-ish. We're gonna finish up this trial. My understanding, it should be done by then. And State and Curtis, do you all have the supplements for me?
Yes, ma'am.
All right, if I could have a copy of that, please. Sure.
I'm apologize, you were still not.
Oh, that's okay. Yes. Thank you. And Will, your client is going to be a late arrival. Something happened with the transportation.
Okay,
All right.
no problem, Judge.
All right. Thank you so much.
Yeah, thank you.
All right, court is calling 2019 CR 10230 State versus RC Curtis. Can I have parties announced for the record for the state,
Stephen Spear.
for the defense? And are you Mr. Curtis? All right. And if you could have your witness take the stand.
There was some around talking up from outside.
All right, thank you.
I promise. You. 40 years. Ouch. But honestly, everyone is.
All right, thank you.
So.
And the witness who
He wasn't happy, but
to testify, is it for
I
these
wasn't
two?
unhappy.
Okay.
You have copies of this girl for me? You're the best. You're a year older today and you look a year older.
Yeah, he is not. Happy birth month, Mr. Harris.
Yes.
Mhm.
This is 2017. Read.
But this is all we're doing is these two?
For those are the only two supplements, that's all that existed at the
Okay.
time. And only from June to April, got arrested. That. Supplement for that one. was done.
Do we have that supplement or no?
That it, but,
We're not gonna do it today?
well,
We'll do it another day?
I think we've already, I'm just saying because when that came, we already got, this was our last submission. This was like that, it was 5 years, I think, probably like we covered it. Everything that was stores, paperwork. Everything stuff, sinking in, that's what they, and that's a class of everything. that I've done.
Everything from last week is on here.
Between Black Friday.
Detective Hines, if you take a seat, please.
Yes, ma'am. Forwarded.
Yes, sir. Sorry.
Oh, you good?
Actually, you can scoot over one if you, no, you better stay right there. I don't want you to move. Stay there. Jump on.
Mhm.
I need pictures of me.
All right. If you're still under oath, if you'll state your name for the record, please.
It's Randall Hines.
All right, so where we are today is there have been supplemental reports that have been presented to the court from the prosecution guide. So we're going to start, for both parties, we're going to start with the supplemental report. That is the longest. And even though it says page 1 of 3, I actually have 9 pages, and it includes a police report. So do you have that before you?
Yes.
All right, so we're going to start with that one.
And Your Honor, if I could, for the court's nomenclature, for this hearing, the base prosecution guide was marked States A, I think we called it.
Mhm.
So the second report, labeled 1 of 3, has a total of 9 pages with offense reports would be states B.
All right, if you could mark that as states B.
Okay, then states C, I apologize.
All right, state C. So if you could mark that as states exhibit number C, please. And then the other document that consists of 3 pages will be marked states exhibit D.
I've got a Sharpie. How do you change?
I don't-
Norma, do you have a Sharpie?
I don't.
If you could, that's that.
Thank you, thank you, thank you. I just don't wanna.
All right, so state C and D have been marked, correct?
Thank you.
Yes, Your Honor.
All right, so state C and D, do you want those admitted into evidence for purposes of this hearing, or are they just for us to refer to?
Well, they can be admitted for the purpose of this hearing, Your Honor.
Any objections, defense?
No, Judge.
All right, states exhibit C and
Oh.
D,
Apologize. Judge.
C and D will be admitted into evidence for purposes of this hearing only. So we're going to start with states exhibit C.
And we have states A, the base report, it just flows.
I will look through that, but let's start.
Okay, we were last in session.
No, just a second. We're on states exhibit C. We're going to go through it line through line.
Yes, ma'am.
Thank you. All right. So both sides are on page 1.
Yes.
Page 1 of the 1 through 3, that's really 1 through 9?
Yes.
Okay, thank you.
All right. With regards to the complainant, of course, there was no statement taken. My understanding is there was a video of the deceased person. Did you turn over that video to the defense? I'm sorry, to the state? When they did a video at
Okay,
the scene?
crime scene video?
Yes.
Yes, ma'am.
And state, did you turn that over to Mr. Bach?
Yes, ma'am.
Mr. Bach, do you have the video?
The crime scene video, I do, Judge.
All right. And then with the next thing we have is statements from Mr. Curtis. Was that audio, video written?
Video?
All right. And did you turn that over to the state
Yes, ma'am.
and defense? Do you have that?
I do, Judge, yes.
Did you take any notes as it relates to the defendant?
No, ma'am, I don't recall taking any notes.
Any questions with regards to those 2 persons that are listed in the prosecution guide in State's Exhibit C? State?
Well, yes, Your Honor, the balance of the prosecution guide for state C. Who did you interview for state C? And I'll refer you to page 2 of 3.
No, we're going page by page.
Okay,
Yes.
no questions in, Your Honor.
All right. Defense, any questions with regards to the complainant and your client?
No, Judge.
All right. Now let's move on to David Rocha. The arrest warrants. Did you turn the arrest warrants over to the state?
Yes,
State, did you turn those over to the defense?
Yes, Your Honor.
Defense, do you have those arrest warrants?
Yes, Judge.
The police reports related to the arrest warrants, did you turn those over to the state?
yes,
State, did you turn those over to the defense?
Yes, Your Honor.
Defense, do you have those items?
Judge, no, but some of those are if I can refresh the court's memory from last week, we talked about police reports from the University of Texas
Yes.
and Leon Valley. Do I have all of those?
Yes, they have been made available to the defense. They referred to the co-defendants Hernandez and Rocha. Those reports have been made available to the defense, Your Honor.
All right. And do we know with regards to that, were there any videos of the
That was
arrest?
my next point.
no.
All right.
And I have all of that here.
All right, so you have all of the.
Yes, ma'am. All the
information.
things that were requested last week, ADA Harris told me to bring it to court this morning, so this is all I have up to this point.
All right,
And all
so,
of this has been emailed to defense, I think.
all right. Any other questions with regards to Rocha defense?
Not on that page, no.
All right, let's move to page 2. With Hernandez. The police reports, were those turned over to the state
Yes, ma'am.
and the arrest warrants?
Yes, ma'am.
And state, were those turned over to the defense?
Yes, Your Honor.
All right, state, any questions as it relates to that paragraph involving Hernandez?
No questions, Your Honor.
All right, defense?
Same questions regarding the other agencies involved in some of his stuff. Did we confirm that there's no videos or anything from any other agencies?
From Leon Valley, I can confirm that there are no videos. I have not contacted UT Police.
And if I may aid to the court, Your Honor.
Yes.
My office has reached out to the UTSA police regarding the arrest report on David Rocha. They're investigating, and I don't have definitive as to the availability today of video for that. I will follow up with it today to inform defense in court. My point is, we've initiated it. I don't have confirmation.
And then, sit on this page at the top of I'm still talking about page,
Yes,
it's marked 2 of 3.
yes.
On the top of 2 or 3, still referring to David Rocha, it talks about the last sentence of that top paragraph, and his apparent going into hiding. I'm curious as to what investigation he did that led him to believe that he went into hiding. Where are the notes as to what investigation he did to find Mr. Rocha and what evidence he has to substantiate that his claim that Rocha went into hiding?
I went to every known address that I had for him and tried to find them through various friends and associates, and I could not find them. So
Do you have a list of all the addresses and the friends and associates that you contacted?
they're in my main prosecution guide.
Can we go back to that, Judge, and I just want to make sure we're talking about the same people. Because I don't remember talking about that last week, going and talking to people about where is more than just.
Charles, I think if you go to page 21 of 32,
21, okay,
Wednesday, November 11th.
thank
and
you. Let's just. 21 of 32.
And begins, Wednesday, November 11th, kind of in the middle of the page.
I talked to Bianca Dunn. Is that the person? Is Bianca Dunn the person you're talking about?
Yes, sir.
So who are okay, you said friends and associates.
Yeah.
Well, that's one. Who are the other?
One, I do recall asking Donald Lee Barnett if he knew where I could find Rocha. And there was also a person who provided information confidentially who I asked if they knew where he was.
And are you able to tell us that person's name?
No,
No, because it's confidential, or no, because you don't have it?
no, because it's confidential, and actually no, because I don't have it.
And
All right, so do you not have it?
I don't have the name, Judge.
Do you know the name?
I do not know the name.
All right.
can I inquire as to why he doesn't know the name? Or why don't you know the name?
Because when someone gives us information and they say, I don't want to give you my name, I don't take their name.
Well, the information they gave you, how, okay, well, without knowing their name, what information did they give you?
The identity of David Rocha and the fact that David Rocha has likely fled the city of San Antonio.
Okay. You said you went to multiple addresses. What addresses did you go to
May I have
confirm
my
that he's?
report?
I'm sorry, go ahead.
May I have my report?
Here.
All righty.
So this is what the court wants to know because this is basically a discovery hearing.
Yes.
So if you can find in your report that you've given the addresses, if you would just tell him what page it's on, please.
Okay, yeah. Okay, one address is 6819 Blacksmith, which is in Leon Valley.
That's on page 21.
Yes.
Yes.
And I'm trying to remember the other address that I checked for him.
I believe could it be also on page 21, 1001 North North San Marcos?
Yes.
I know of those two addresses. I'm just curious if there's others.
No, if those are the only two that
Okay.
are in the report, then
Okay.
that's the only two.
Okay, thank you.
Mhm.
That's all I have regarding that, Judge, regarding that top paragraph.
Okay. Any other questions about the top paragraph?
No,
Uh,
Judge.
State.
And we're referring to the top paragraph of states A or state C.
C, we're still on that same page. I mean, that
Nothing
same
from-
document.
Nothing from the state, Your Honor.
All right, then let's go to the details. Scott Pettis, did you bring the information or the documents related to Scott Pettis with you today?
Yes, ma'am.
All right. And does that include audio, video? Did you turn that over to the state?
Yes, ma'am.
State, did you turn that over to the defense?
Yes, Your Honor.
Any questions? State or defense?
Nothing from the state, Your Honor.
Defense?
No, I have Mr. Is there just one interview with Scott Perez?
Yes, sir. That's it.
I have that one interview, Judge.
All right, we'll move on to page 3.
Well, no, in the paragraph, it discusses a flip of this telephone. Did you do anything to investigate this telephone? In the bottom paragraph on page 2. The bottom paragraph, as you state, is a summary of your statement.
Yes.
And it specifically discusses a telephone
Yes.
and a motel. Did you investigate anything that you learned in the summary that's described in page 2?
As far as trying to find the phone that he described during his interview? Yes.
And the motel that's located in Ingram,
Yes, sir. I went there and I spoke with the manager, and that's in my main report.
is that some of the stuff we discussed last week?
Yes, sir.
Okay, okay.
Yes. Mhm.
Now, what about the telephone?
What do you mean, what about the telephone?
Did you, the next sentence, the Alcatel flip phone?
I've never seen an Alcatel flip phone related to this case. That's only what the witness said.
Okay, all right.
All right, then page 3. The person named Zombie, were you able to identify who Zombie was?
No, ma'am.
All right, did you ever speak to anyone about Hernandez's cousin named Zombie?
No.
All right, with regards to the single photographs of persons involved in the case, did you turn over the photographs or copies of the photographs that were used for identification to the state?
Yes.
State, did you turn that over to the defense?
Yes, they have all been made available to the defense, Your Honor.
All right, with regards to that page, any questions, state,
No questions from the state, Your Honor.
Okay.
defense?
Do you have a list of names of the people you asked about Zombie and who that might be?
No.
Did you investigate Frank Hernandez's relatives?
No.
did you specifically ask Bianca Dunn about Zombie?
I don't recall asking her about Zombie.
Because she did say she was his girlfriend, Frank Hernandez's girlfriend, correct?
Yes.
I guess that's all I have for that page, Judge.
All right, we'll move on to the next page. And the next page is just information on Pettis's address and information of contact persons or collateral persons who may be able to contact him. Any questions with regards to that page, state or the defense?
Nothing from the state, Your Honor.
I'm sorry, just one moment. With regards to that page, did you speak to the spouse of Scott Pettis?
No, ma'am, I did not.
All right, did you speak to the aunt of Scott Pettis?
No, ma'am.
Did you go to the location listed as the aunt's address?
No, ma'am.
All right, any questions, defense?
You have there on that page the telephone number of Scott Perez. Because Scott Perez gave you information about cell phones and videos and things, I'm assuming you did something with Scott Perez's cell phone. So what did you do with that cell phone number?
With this number, I didn't do anything with it.
You didn't track it. You didn't get a warrant for it. You didn't do anything with it.
Not for this number, no.
Did you do anything with any phone numbers associated with Scott Perez? I'm sorry, Judge.
The phone number that I was provided, that was a phone number during the time that this incident happened, was get the subscriber information. And that is on page 29 of 32 of my prosecution guide.
So we discussed that last week.
Yes, sir, we did.
But you agree with me, that's a completely different phone number than the phone number that's listed for him in this report.
Yes, sir, that's correct.
And so you're positive. I mean, and I only ask because we've had some phone number issues, if you will, that there's nothing regarding this phone number anywhere. No investigation, no grand jury subpoenas, no phone dumps, no tracking maps, no nothing for this phone number, 7-210-769-2623.
There is no investigation.
Okay.
All right, we'll move to the next page. And we're going to take these 3 pages of this police report together instead of by sections. All right, so in reference to the next 3 pages. The person listed as Angela Christman. Did you have any contact with that person?
No, ma'am.
Or do you know if any other police reports or any other interviews or statements were taken from that person?
No, ma'am, I don't.
And then on the 3rd page, with regards to RP1, which is Chrisman, is there any incident detail report related to that or no?
There probably is an incident detail report related to this case number. Yes, ma'am.
All right. Do you know if that was turned over to the defense?
No, ma'am, I didn't turn over an ID.
I'm sorry, turned over to the state?
No, ma'am, I didn't.
And do you know if the co-ban was turned over to the state?
No, it was not.
All right. So on that page, I'm being told that the code was turned over to the state, nor was the incident detail report. And that's from page 3.
Yes.
And there's also Child Protective Services listed as the employer of the reporting person. So did you receive any CPS related to this report?
No, ma'am.
Did you look for any CPS records related to this report?
No, ma'am.
And do you know if anyone from CPS talked to anyone?
No, ma'am.
And it states that it says RP1 stated that they were told that the person was living out of their sister's car. Did you ever contact that sister?
No, ma'am.
All right, any questions, state or defense?
No questions from the state, Your Honor.
So would those, no, so you, last week, you said that in 25th, and if I believe you said in 2015, you verified that nobody had body cameras. Is that correct?
Yes, sir.
So what, this happens in 2016.
May of 2016.
So were there body cameras in play by then?
I don't know, sir.
And if there were, are they still available?
No, these will not be available. They have been purged. This is just a wanted person being arrested on traffic. So,
But isn't this a wanted person that turned out being a suspect in a murder case?
Scotty Perez? No, sir.
This isn't the Scotty Perez who said that he had a video of a murder on his phone?
Yes, sir, it is.
All right, so those questions are for cross-examination. So do you have the Coban, is the Coban video available or not?
No, ma'am, it's not.
All right. And the municipal court warrants, do you know if there are police reports related to that or not?
This is the police report related to it.
All right, I mean, for example, the municipal court warrants that are listed on here,
Mm-hmm.
what are those warrants for? It doesn't say in the report.
I have no idea, ma'am. It's probably
that's-
traffic tickets.
All right, so that's what I mean. Do you have access to what those municipal court warrants were for?
I can find out.
Okay,
Not, okay.
and then with the incident detail report?
May I write on this?
Yes.
That's it.
Oh, wait a minute,
See
not
it
that
there.
one.
Okay.
That's it, but they're gone.
If you want, do you want a piece of paper to take a note?
Yes, ma'am, because not sure why.
Just 1 second.
Okay.
I mean, perfect. It's only municipal ones. It's gonna ask the question.
Oh, no, he also had a bolo
Ah,
attached
thank
to
you.
his name, so.
I'm just trying to select if you got arrested.
All right, so if you could see about the incident detail report, please.
Okay, so
I'm
I
just
need
curious, I'm gonna ask him about
IDR.
this part, what this was all about.
And then
This
just,
was
I
his
know they've
bolo,
probably been
but it
purged, but
was
if you can just make sure that the Coban video no longer exists. All right, any other questions with regards to that police report?
Yes.
Vince?
Yes. In the middle of that last page, it says AP1 also had a bolo attached to his name to get hold of a detective. Was that your bolo you had placed on his name?
Yes, sir.
Okay. And when you have, as I understand the bolo, that's something that's put into the system, correct? It has some information attached. It tells, hey, be on the look, and bolo is be on the lookout for, correct?
Yes, sir.
Okay. Do you have a copy of what information you put into the system and why you wanted him found, or what you wanted him found for?
I can probably get that, sir.
Okay, will you please do that?
Okay.
All right, any other questions with regards to those 3 pages of police report?
Who transported him to the headquarters? Was it the same officer that took him into custody? I don't think so, because he was sitting in the lobby. Did you transport him?
No,
Who transported him?
the report says transporting officer is Bridget Newman. That's, Page 2 should be on page 1 also. Let's see.
I'm reading the little, let me go to we're still on the first 3 pages, correct, Judge?
Yes.
Okay, so I spoke RP1, she had him, warrants. ran him.
Okay, if you're asking about this officer's report, Bridget Newman, they would be better to answer these questions about their report, what they wrote in it.
All right. Any other
Okay,
questions?
no, it'd be, as long as Judge, he can get me a copy of that, of the bolo that he generated for this matter. I understand is it on the Newman thing, but if he generated the excuse me, the bolo, I'd ask that I get that.
All right, if you can make sure of that. All right, then we're gonna move on to the last 2 pages. All right, the last 2 pages with regards to Payman Reed. Is this the only police reports that's related to Reed?
It's gotta be looking at. And I don't have it found in the front.
Counsel, I'm sorry, Detective.
Is this the only?
All right, everyone,
No.
you all need to quit doing this cross talking because we have a witness on the witness stand. All right, so,
Okay, when you say that the only report not related to this case, there's a couple of reports that are referenced in my prosecution guide as to how I found his address and an incident that he had with a young lady.
all right,
So
all
this is not the only report with Cayman Reed's name.
right, so you do have it in your prosecution guide, correct?
Yes, ma'am.
All right. And with regards to his arrest, was that videoed or not?
Let's see, and I would have to confirm. He was arrested on March 6, 2017. I think is what this is.
All right.
Okay.
And also, do you know if you interviewed him, audio, video, or anything of that nature?
He was interviewed on video by Detective Ruben Perez, and Detective Perez is retired now.
All right, and did you give that video to the state?
I did, yes, ma'am.
State, did you give that to the defense?
Yes, I believe it's made available to the defense, Your Honor.
All right, any questions, state or defense?
Yeah, I'm sorry, I have no idea where we are now. I thought you went to this traffic report.
We're on the second page. We're on the second police report because you all said you were finished with the first police
Right.
report.
So what I was asking Mr. Harris is my report that I was handed ends and during the search incident, a small baggie containing a green leafy substance was found in the front.
That's the page we're on. We're on those last 2 pages.
Right, but I mean, clearly there's got to be more to it.
Well, you can ask those questions. What the court has is starting on page 1 of the second police report. It says at the top, SAPD 17051212.
Yes.
That's page 1.
Yeah, yeah.
And then there's a second page to it. I do not have where it says page 1 of 6. I only have 2 of 6.
I agree. But you were asking him about, he's talking about a detective interviewing somebody. I don't know where on earth that's coming from on these 2 pages. That's what I didn't
Asking him
understand.
questions about Mr. Reed. So I'm asking him with Mr. Reed, was he ever interviewed?
Yes,
All right, was that interview recorded?
yes,
Did you mention that in your prosecution guide?
yes, ma'am.
Was that interview turned over to the state?
Yes,
State, did you turn that over to the defense?
Yes, Your Honor.
So those are the questions that I had. And state, this appears to be 1 of 6 pages, but I only have 2 pages.
Mr. Harris has given me a more complete packet. Do you have can we make another copy for our
Yes,
office?
we will make another copy. Printer problems, funny enough, Judge, I thought they were all complete. Apologies.
Yes, we didn't mark A. I'm gonna make them mark it. All right. Thank you.
Yes.
Do you have all 6 pages?
No, ma'am, I only have 2.
All right, I'll ask you questions and I'll give this to you.
Yes, ma'am.
I gave you my copy.
Yes, you did.
All right, so we're working through the pages. So we're on page 3 of 6. With regards to Fuente, he's mentioned in that page. Did you contact her or make contact with her?
No, ma'am.
With regards to Richardson and Santiago, did you make any contact with them?
No, ma'am.
I'm sorry, Judge, can you tell us where you are? I'm sorry, I don't mean to interrupt. I just don't know where you are.
Page 3.
Sorry, okay, thank
No
you.
problem. All right, now we're on page page 5 of 6.
Page-
The 3 Capital One checks belonging to the mother of the arrested person. Were you able to obtain copies of those checks or have copies of those checks?
No, ma'am.
Did you take any photographs of those checks?
No, ma'am.
Then on page 6 of 6, the passengers that were in the vehicle with AP1, 01, 02, and 03. Do you know if they were questioned?
Not by me, no, ma'am.
Do you know if there's a video of the arrest or AP1 being pulled over?
I'll have to check and find out.
All right, and then where it says statement information supplement. Did you ever do any more investigation work as it relates to the here? Did you ever do any more investigation work as it relates to the checks that were being referred to? The $2,500 check,
Okay, which,
to see whose name was on it?
okay, are there checks mentioned? Are you asking me about the checks mentioned in this offense report that we're going over right now?
Yes.
No, I didn't do anything with those checks. From my understanding, there were checks belonging to Cayman Reed's mother or something.
Okay.
Yes, ma'am. So,
And then
no,
the check for $2,500 that's listed in there?
No,
Did you ever do any investigation with regards to that check?
no, ma'am.
All right, any questions, state or the defense?
No, Your Honor.
Yes.
Yes.
And here's the problem with what we're doing. I mean, you ask him, were there any videos, and he says, not by me. So then we just move on. Well,
No, we're not moving
I
on.
understand, but I mean, he
Here's
kept
the
going.
thing, you all know that he's not the person who said he did a video. The next question
So
becomes, does he know who did the video? That's it.
That's where I am. So do you know if there were videos? I mean, if there were any videos done
When videos of the arrest?
of anything? She asked you, were there any videos taken of him? And you said, not by me. But that doesn't satisfy the requirement of discovery. So I mean, I understand you didn't video him, but when you looked into this, were there videos?
Not that I'm aware of, and I'll have to check. And when you say videos, are you talking about patrol car video, body cam? The only video I can speak to in regards to all those names she's asking me about is Cayman Reed. So I'm not sure. All these other people listed on the report, I've never dealt with them.
And you interviewed Cayman Reed, correct?
I did not. No, sir.
Who interviewed Cayman Reed?
Detective Ruben Perez, and
And-
he's now retired.
Right, and there's only and that was one time, is that correct?
That's correct.
And that's the video that I already have.
Yes, sir.
Okay, now, what about reviewing the body camera of when he was Did you review the body camera of when Cayman Reed was arrested?
No,
And when he was arrested, there was another bolo for him as well, correct?
correct.
Can you at least get me a copy of that? Is that another bolo that you generated?
Yes, sir.
And can you get me a copy of that at least?
Yes, sir.
Okay. Now in this packet we were given during our little break, there's some pictures that are attached. You didn't do anything with these pictures. These are all from the now retired detective, correct? There's some handwriting, and you see those toward the end. I guess they would be the three of the last 4 pages
Yes.
have pictures
Mhm.
and handwriting. That has nothing to do with you, correct? That's from Detective Perez?
Yes, sir.
Okay.
That's correct.
Did you have an opportunity to watch the interview that Detective Perez took from Cayman Reed?
Yes.
And as a result of you reviewing the video, did you do any further investigation from any information you may have garnered from that video?
No.
Okay. Did you, there's a phone number written for Cayman Reed of 210-974-7664. Did you, or any, to your knowledge, let me rephrase my question based on my own observation. Did anybody do you know of anybody getting any information from that cell phone number?
No.
Did you ever attempt any follow-up interviews with Cayman Reed?
No.
Okay.
And off the record, do y'all know if the other inmates have arrived? All right, thank you. All right, we're back on the record. All right, he can-
Were you surprised to see that his car insurance? No, hold on. Now, when last week on 22 of 32, you said you found information with an address of 608 Hamilton Reed on the police report. But that was dated 2015 and this report is 2017. So it's a different police report, right?
Correct.
But it's the same address, 608 Alexander Hamilton, that his insurance is registered to. Did you tell us I don't remember, did you tell us last week that you went to that address?
Yes.
Okay. Did you Forgive me if I asked you this last week. At any time, did you get a DNA sample from, Cayman Reed?
No,
I guess that's all I have then, Judge.
All right. Then we're going to move on to, I believe, what is marked as State's Exhibit D. And that's one of 3 pages.
Did you say D as in David?
Yes.
Okay.
It's the one that's one of 3 pages. It is State's Exhibit D. Is that correct, State?
Yes, Your Honor.
All right. So on page 1, I believe we've gone through information with regards to the complainant and with regards to the defendant. And again, with regards to Mr. Rocha, the arrest warrants, is that included in the documents you brought with you today?
the arrest warrants, they've already been turned over.
All right, and the police reports related to the credit card, debit card abuse and fraudulent use of identifying information?
Yes, they've been turned over to the state.
All right, and State, you've turned those things over to the defense?
Yes, Your Honor.
All right, any questions from either side with regards to page 1 of 3 of State's Exhibit D?
Not from the defense, Judge.
All right, then let's move on to page 2. All right, with regards to this $2,500 check, I believe you stated previously that you never did an investigation to discover the name on the $2,500 check.
No, I did not.
Do you know if anyone discovered who the $2,500 check, who the names that were written on the $2,500 check?
No,
And did you speak to the teller from the bank, from Chase Bank?
no, ma'am.
Do you know if anyone spoke to the teller from the Chase Bank?
No, I don't.
Do you know if any videos were taken from the Chase Bank with regards to Reed presenting the check for $2,500?
No, ma'am.
All right, any questions with regards to page 2, State or the defense?
None from the state, Your Honor. And for clarity, Your Honor, I just realized all the offense reports, 6 through 9, we went through with Exhibit C, they really support this prosecution guide D. My apologies to defense and the court in the haste to make them available.
All right, any questions? defense?
When Perez interviewed Cayman Reed, were you present?
I was at in-service,
Yes, sir.
annual training.
Okay. Did you have an opportunity maybe to step out of training and talk to him before he interviewed Cayman so you could kind of bring him up to speed with what you needed from Cayman or what this was all about?
Yes,
Okay, and do you remember, did you share, did you send him any information or refer him to any notes you had or anything in particular so he'd be able to ask intelligent questions? And how would he know what to ask? I mean, in other words, how did he know what this was about?
well, he called me, I was in service and
Yes,
he
sir.
sent me a text message, said, hey, you know, one of your guys that's in Bolo patrol has him. And he called me up, I gave him the case number and I let him know what information I needed. There was an allegation that this Cayman Reed guy had one of the checks, a check that came from Miss Boyd's bank account. And I needed to get him questioned about that.
Where did you get the allegation that Cayman Reed had the check?
We addressed this last week, but let me go through and find it.
Is that on page 22? Is that the same check? Because that's a $2,800 check on 22. And this is a $2,500 check. I'm just.
This information is the only information that I have regarding a possible check that belonged to Ms. Boyd being in Cayman Reed's possession.
Okay, so that's the same, we think we're talking about the same check.
Yes, 2,800, 2,500.
Okay. Did you send any other information to Perez at that time, or did you just refer him to your prosecution guide or your reports?
Yeah, I just told him in a nutshell what I needed and just interview him about that, and he did.
Did you provide him with the photographs to show Cayman Reed?
He probably got them himself. He had to look through my report and find the names and dates of birth of these guys and show him the pictures.
And then, okay, and then Judge, at some point, okay, well, I'll address this. Okay, then that's all I have for this detective regarding that interview.
All right. Then what we'll do is the information that you brought with you today,
Yes, ma'am.
if we'll make sure that defense has copies of that. And then we will come back Friday of next week. Is everyone here? I know holidays are upon us, but if everyone could please check to see if they are going to be here on Friday.
I'll be here, man.
I know. The work never ends.
Mhm.
And that's Friday, the 20th.
And ma'am, may I ask the defense a question?
Yes.
Okay, so when you want copies of these bolos, do you want a step-by-step as to how I get to the bolo to get it for you, or do you just want the bolo?
Just the whatever the release is, whatever you put onto the system, sir.
Okay.
Thank
all right,
you.
Okay.
Judge, I'm gonna be in a trial next week, so I can't commit. I mean, I'm plan on being here,
Mhm.
but I'd like to leave as soon as the trial's over.
All
My
right.
family would like me to leave as soon as the trial's over, but
All right. Then what we can do is we can schedule it for let me check my calendar very quickly. All right. Norma, are we able to put this on January 8th?
Yes, ma'am.
All right, so that'll be Wednesday.
I'll be out of town.
Oh, you'll be out of town.
Yes, ma'am.
All right, when will you be back?
Oh, January the 11th, I think. Well, no, I take that back. Let me pull out my phone. Okay. I'll be on vacation from January 5th through January 11th.
All right. Do we have trial scheduled the week of January 13th? What are we have scheduled? Is it a murder case? What is it?
Give me 1 second. Yes, you have one.
All right. Is everyone available on January 22nd? Are you available January 22nd?
Yes, ma'am.
yes, Judge.
All right, so we'll put this down for discovery January 22nd.
You also have trials on Tuesday.
That's okay. And on that date, we'll need to have everyone here exactly at 9 a.m. All right. And Norma's telling me we have trial that week. I don't know if it's a murder or not. What is it?
We have a couple of cases.
All right, so she can't tell me. It's a secret. So nobody's answering my questions today. I don't know why. So
It just doesn't have.
9 a.m.
That's right.
All right, so we'll be here on the 22nd at 9 a.m. And if you all could, because I know that there was one exhibit that was marked. I don't believe the prosecution guide was marked and placed in evidence. If you all can make sure that that's marked and placed in evidence for this hearing. And also I think it was C that only had the 3 pages or whatever, and then it was completed. If you'll just add that to it.
Yes, ma'am.
All right. Is there anything else? And in case people don't have one, I gave him the copy that was given to me of the prosecution guide with the purple clip. So if y'all don't have yours in defense, if you have no objections, then that can be marked as A if it was A.
You can make a set duplicate to ensure the court has the ability to follow.
All right.
See the
is-
obvious line.
All right, thank you. Is there anything else?
Regarding some of these other detectives, like Detective Perez, who interviewed Cayman Martin outside the presence of this detective, can the state just contact that detective and make sure there were no other photographs shown? I mean, there's no way for this detective to verify that. So can the state just make sure there were no other photographs shown or any?
If you all will confer on that matter, and then if there's an issue or
Yeah, we
defense,
will-
you
we
feel
will.
as there's something
all right.
else that needs to be heard, those persons can be called.
Okay, thank you, Judge.
All right, thank you. If I don't see anybody, you all have a happy Christmas. Merry Christmas, happy Kwanzaa, happy Festivus for the rest of us. All
Thank you, Judge.
right,
Okay, so then.
and enjoy your vacation.
Yes, ma'am. Thank
Used
you.
Until January 22nd. All right, all right.
In-laws, 89 years old.
Oh, that is so awesome that they're still around to enjoy.
Yes, ma'am.
All right.
Sorry, I did not know you were behind me.
I didn't, that's everything that I emailed. Right.
Excuse me, are you all ready for whatever you're gonna do with the inmates, or there's some paperwork?
Get on this.
I'm sorry?
I need to convey an offer to my client.
There's a plea ready. You may make copies of anything.
All right.
I know that instance.
All right, so then what we
Okay, I
can
didn't
do
Anything right now.
is, do you know if the courtroom next
There's no
door is
bad
available?
It is.
All right, so, defense counsel, they'll let you see your clients next door in that courtroom, and when everybody is ready, just let us know, and I'll take you up during a break. All
All right, thank you.
right, thank you. Thanks for understanding. All right, and- Deputy.
I know, right?
I know, but the bottom line is. Hey.
So what? No, what I said was, I don't allow people who are underage to be recorded. It doesn't
That's what I
matter
thought.
the offense.
That's what I thought.
All right, thank you.
Didn't even notice that till halfway through the hearing. It's like, okay, don't laugh, don't laugh.
Can't have fun.
Exactly. It's better to laugh than cry. Right?
This was not a legal plea.
All right, if you all would take a seat here, please.
400 with intent was minimum 15 years.
All right, thank you.
Unless included, less included.
Well, just a moment, let me clear this
So I
up
believe
first.
we're Okay, but I believe that it has to be. Well, I guess deferred can be less than what it is, so. Anyways, I mean, it's a good deal, I mean, for the guy, but I mean. Okay, we're gonna have to switch that up.
All right. I didn't want to mess with it. Yeah.
Judge, I'm sorry, can we approach?
Yes.
Thanks, Judge.
Sorry. This was all worked out, but then I started reading it. It's,
All right, court. All right. All right, court is calling 2023 CR 4707 State versus Christopher Morrison. Can I have parties announced for the record for the state,
Megan Galloway for the state.
for the defense?
Shannon Locke for Christopher Morrison.
All right, and are you Mr. Morrison?
I am, ma'am.
And also for the state?
Andrew Harris Edelman.
All right, my understanding is that the jurors are now all present. The reason why we didn't start at 10 is because the jurors were not all present, but they are now. Are both parties ready to proceed?
Yes, Your Honor.
And I understand your witness. Okay. All right, thank you. Is there a piece of paper from the last hearing in front of you, Mr. Locke, in front of your computer?
I'll supply.
Okay, all right, thank you. Two minutes. Their witnesses in the restroom.
You guys brought Rodriguez back.
Correct.
He's here, Your Honor, and we're ready.
All right, have her take the witness stand, please. All right, let's bring the jurors in. Can you just stand out in the hallway, tell them to bring the jurors in, please? Yes.
All right, Virginia.
All right, everyone, please be seated. State, call your next witness.
The state calls a Detective Danielle Rodriguez.
All right, could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth so help you God? All right, you can lower your hand. Make sure you keep your voice up so that members of the jury can hear. All right, if you'll spell your name for the record, please.
Danielle, last name Rodriguez, Rodriguez.
All right, state.
Thank you, Judge. Detective Rodriguez, are you the same Detective Rodriguez that testified in this trial yesterday?
Yes, I am.
And is all of your training background and experience the same as to what you testified to yesterday?
Yes.
Okay, and so yesterday after your testimony, there was some mentions of 911 calls that were made in this matter. And so as part of your investigation, do you collect 911 calls?
Yes, I do.
And how do you do that?
I send an email with the case number requesting them.
Okay, and did you do that in this case?
Yes, I did.
Okay. And so yesterday there was testimony that Jesse Izagita made a 911 call to SAPD on June the 3rd of 2022. Yesterday when you testified, did you have knowledge regarding that 911 call?
No, I didn't. Did he make that?
Yeah.
Yes, yes.
And so when you submitted your request for 911 calls, how many calls did you receive from 911?
Two.
Okay, and those two calls, they did not contain Mr. Izagita's call, correct? Okay, and so when SCPD receives calls for service or 911 calls, is there an information sheet that is generated to kind of keep track of what calls are coming in.
Yes.
Okay, what is that called?
Incident detail report.
Okay. Your Honor, may I approach the witness?
Yes.
I'm tendering to defend for inspection. All right, Detective Rodriguez. Now I'm showing you what's been marked as State's Exhibit A and State's Exhibit B for identification purposes only. You recognize these two documents.
Yes, I do.
Have you seen them before?
Yes.
And were they tendered in discovery as evidence in this case?
Yes.
Okay, and so can you tell me what was the discrepancy regarding the 911 call made by Mr. Izagita?
Mr. Izagiri made a 911 call as well as another resident who was a victim. And when officers responded, they assumed that Izagiri was just making the call as courtesy officer for that.
I object. This is non-responsive and
Any
question
other
calls for narrative.
objection?
What's that?
Any other objection other than non-responsive?
And she's speculating, Your Honor.
Sustained.
Can the jury disregard, Your Honor?
Ladies and gentlemen, you disregard the last answer from the witness.
And I would ask for a mistrial.
Denied.
And so in your investigation of the case, did Jesse Izagita make a call to 911?
Yes,
Okay, was that call preserved?
it was not.
Okay, and why is that?
An officer,
Judge, again, only if it's within her personal knowledge, it calls for speculation.
All right, lay the foundation.
So when you were investigating this case, did you make a request for all the incident detail reports that were associated with this defendant and the location?
no.
Okay, and so how did you come into possession of the incident detail reports that are before you? Did you pull the incident detail reports that are labeled as State's Exhibit A and B?
Yes, I did.
Okay, and did you do that in the course of your investigation of this offense?
Yeah.
And so then, how do you know that Jesse Izagita made a 911 call?
Because on this incident detail report, he's listed as the person, the caller. And it documents that he dialed 911.
And in the course of your investigation, did you attempt to retrieve that 911 call?
Yes, I did.
And why were you unable to retrieve it?
It was purged.
And what is SAPD's retention policy regarding 911 calls?
All calls are purged after 90 days.
Okay. And so you conducted an interview with Jesse Izagita on June 4th of 2022, correct?
Correct.
But it was regarding an incident that occurred, or the offense that occurred the day before on June 3rd, 2024, correct?
Yes.
Okay.
Sure.
Okay, and so yesterday, Mr. Locke asked you whether you knew for sure that the defendant shot into the pool with a BB gun. And yesterday you stated you didn't know for sure, correct?
Correct.
But what was the conclusion of your investigation?
The conclusion was,
Judge, I'm going to object to relevance.
Overruled.
You can answer.
the conclusion was that Jesse was being fired upon due to his statement of hearing a weapon being wrapped. The fact that there was damage to a balcony window consistent with a BB gun. And then lastly, the defendant's admissions when he was arrested.
Okay, and so regarding that other apartment that was fired upon, did you have the opportunity to examine that apartment?
Yes, I did.
Okay, and were photos taken of that apartment at the time of the offense?
Yes.
I'm tendering state's exhibits number 8 through 11 to defense for inspection.
Judge, may I approach?
Yes.
Okay, and have you seen those before?
Yes, I have.
And are they a fair and accurate depiction of the apartment on the date of the offense?
Yes.
Okay. Okay. So I'm gonna show you these again. Can you explain to the jury what is depicted in state's exhibit number 8?
And the apartment, the 303, apartment number.
And regarding state's exhibit number 9, what is depicted in state's exhibit number 9?
A shattered back window with a small hole in it.
And how many holes are in that window?
1.
And is that the window of apartment 303?
Yes, it is.
In state's exhibit number 10, what is depicted?
A closer up photo of the entry, the bullet entry.
And state's exhibit number 11.
Closer up version of the damaged entry.
And so ultimately, the defendant did voluntarily surrender himself on June the 9th of 2022. Is that correct?
That's correct.
And yesterday there was mention of some statements that you reviewed during the course of your investigation that the defendant made to Officer Kelly Ashby. Is that correct?
That's correct.
And so the defendant made a couple of admissions, or how many admissions did the the defendant make to Officer Ashby?
Read that phone call.
Okay, and can you please state those to the jury?
The first one, stating that he's from Indiana and he'd, commonly shoots off of the balcony, while at home. The second saying that, it was just a BB gun, he didn't think it was a big deal. And then the third was, him saying that he's here because he did, or he was there taken in custody because he did something wrong.
And in fact, he admitted to shooting into the pool, correct?
Correct.
Okay. And so ultimately, what was your decision based on the investigation that you conducted?
To have, him arrested for 2 counts of aggravated assault with deadly weapon.
And why did you decide to go with that charge?
The weapon, used was determined to be a deadly weapon.
We passed the witness, Your Honor. Difference.
Thank you, Your Honor. So when you requested these emails or when you sent the email, what day was it?
I couldn't tell you right now. I just after the investigation, after I received the investigation.
This was your email, correct?
Correct.
And it's part of this investigation, right?
Yes.
Did you turn it over to the state?
Yes. Oh, the email?
Yes.
No, I did not.
Why not?
Because the request of the 911 calls and 911 calls were turned over.
But so when did you make the request for the 911 calls?
I can't tell you a specific date, but I mean, commonly, like the day that I get to receive the case, that's when it's requested. So,
But you didn't save that email?
no,
Did you delete the email?
I did not delete it, no.
So you have the email somewhere, you just didn't turn it over to the state, correct?
Correct. Well, we don't turn over those emails. The state knows that 911 audio is there because it's there in the evidence.
But here, it wasn't there, it was purged. Correct?
Correct.
You're saying that, so it was purged, you requested it, but somebody purged it anyway, correct?
I requested the 911 audios for my case number.
So who did you arrest for the sliding glass door?
I did not arrest anybody.
You didn't make any arrests.
No.
You still have the ideas?
They're up there.
Just leave this guy. How does San Antonio Police Department, how do they classify different calls? Are there priorities given to the different calls?
Yes.
Is a shooting typically the highest priority?
Yes.
How does that show up in an IDR?
Shooting in progress or shooting?
Okay. And is it assigned a priority
Yes.
on the IDR?
A priority? I mean,
Yeah.
Does it say priority? No.
What would it say to indicate to somebody like me that it was an emergency or a high priority or something like that?
Just the title itself is shooting in progress.
What is the term incident type? What does that mean?
That means that it's a call for service.
Okay, so an incident, but are there different kinds of incident type?
Yes.
What are they?
Shootings, information reports, mental health calls. It could be anything. Any call for
How
service.
how is this call classified?
It was classified as information report.
As an information report?
Yes.
Okay. Sergeant Izagire, he testified that if there's a shooting, that receives a high priority designation. Is that right?
That is correct.
If a police officer is involved in a shooting, that's a high priority investigation, correct?
Correct.
He is a police officer, as all police officers are, 24 hours a day, 7 days a week, correct?
Correct.
Okay. Can you, according to this State's Exhibit A, when was this call made? On State's Exhibit A, when was the call made? If I could approach the witness, I apologize for not asking.
Yes.
The call for service,
So you're looking at A and B right now, right?
it's a continuation.
Is that one document?
There were several calls linked.
What was the first call that was made? From the document that you have in front of you.
Okay. This, the first call was at 8:22.
At 8:22? And who made that call?
An individual by the name of Rachel Rotaliata,
Okay.
or excuse me, Jesse Esagiti.
At 8:22.
Yep.
And he said that this happened when you talked to him on the 4th at 7:15, correct?
Correct.
That's 7:15 PM. 8:22 PM is when he made the phone call, correct?
Yes.
Okay. Now here, they're discussing the sliding glass door, correct? You just check. This is all a discussion about the sliding glass door, correct?
It's comments entered by the call taker.
Object to hearsay, Your Honor.
Sustained.
Were these calls made related to the sliding glass door or to the or to a shooting at a police officer? And I'm just asking about Exhibit A right now.
This one, okay, to the sliding glass door.
Okay. Was the person certain that the sliding glass door had been shot by a BB?
I don't know the,
I'm gonna object us to speculation and hearsay, Your Honor.
All right, that'll be overruled. You can answer if you know the answer.
not sure if it was BB gun or rock.
And the priority that it's assigned on this incident type, okay, for State's Exhibit A and State's Exhibit B, I'm just going to direct your attention here. What does it say?
A routine.
What does that say?
Routine.
It's not assigned a high priority, is it?
No.
Yesterday, you said that you spoke to Jesse Izagire once. Is that right?
Correct.
And you spoke to him one time, and that was at the, Your Honor, I'm gonna need to get,
Yes, you can approach.
actually, that's good. So yesterday, you spoke to, you said you spoke to Jesse one time, correct?
Correct.
Are you two friends?
Yes.
You're friends? You know each other pretty well.
Yeah.
You have his contact saved in your phone?
Yeah.
So you guys, have you ever worked under him?
No.
You've never worked under him?
No.
Okay, but you know each other. How do you know each other?
Classmates.
So you went to the same academy school?
Yes.
Would you say it's fair to say that you have a passing knowledge of each other? You're pretty familiar with each other.
Say familiar with each other.
I don't mean familiar. I mean you're friendly.
Sure. Yes, he's my company.
Okay. What do you call him? What's your name for him?
I'm gonna object as to relevance.
Sustained.
Ben, Judge.
All right, here's the thing. I made my ruling. Move on to your next question.
So may I approach?
Yes.
But it's your testimony that, and Judge, to publish an exhibit, could I use how do I use the court?
Well, if it's working, you're more than welcome to use it. We've had IT to come down this morning.
So it was not working.
No, you can try it though.
Oh my gosh. Okay. But you only spoke to, and you call him Izzy. You only spoke to Izzy one time.
Objection relevant, and the court has made a ruling on that, so I'm gonna object to sidebar.
That'll be sustained.
Is that your testimony that you only spoke to him one time?
Regarding the incident, yes.
Okay. So. And the sequence of events that you described was you guys arrive and then you talk to Izzy, right? Sergeant Aguirre. You speak to him and then you go outside with him and you see Chris on the balcony, right? And then that's when it becomes a high priority and you go up and talk to him and you knock on his door. That was essentially the sequence of events, correct?
Yes.
Okay. And before that, you hadn't spoken to him, right?
I had received his statement inside the lobby.
Right. And I'm just going to ask you, I'm going to approach Your Honor.
Yes.
What's the timestamp on this video here?
1:57 p.m.
Okay. And it's because it's military time, 13:57, and it's on June 4th, correct?
Correct.
Okay. And you guys didn't make any arrests on June 3rd, correct?
Correct.
You didn't resolve any of these situations, right?
I wasn't even aware of the case on June 3rd.
You hadn't been assigned it yet, right?
Correct.
Okay. And I'm just gonna. So that's 13:57, and I'm just gonna ask you if you recognize. This is your body cam, correct?
Yes, it is.
And you've seen it before?
Yes.
And you recognize the voices on here?
Yes.
And who is speaking on this body on this recording?
The Jesse Zagiddy.
And yourself, correct?
Yes.
So.
Your Honor, I'm not objecting. Can we-
Sustained.
And that was it.
Counsel,
Yes.
that objection is sustained. Has that exhibit been admitted into evidence?
I'd move to admit.
No, my question is, has that exhibit been
Not-
admitted to the evidence?
No.
Well, you're aware that that is not to be played before this jury unless it's been admitted. So your objection is sustained.
I move to admit defendant's exhibit.
You haven't laid the foundation.
Is that a fair and accurate representation of your conversation with Mr. with?
And what exhibit is that?
Sorry?
What is the exhibit number?
Judge, and I'm gonna object to him facing the screen towards the
All right,
jury.
ladies and gentlemen, I'm gonna have you all step outside just briefly. Everyone, please rise for the jurors. Be off the record. Have a seat. Counsel, you're aware, are you not? That you are not to play videos, especially video and audio, before this jury when it's not even been admitted into evidence. You're aware of that, correct?
I was just establishing that she was identifying the exhibit.
That's my question. Question is, you're correct that audio, video, even photographs are not to be shown to the jury unless they're admitted into evidence.
Yes, Your Honor.
So that is not to be done.
Okay.
And
I was just
I
asking her.
understand when people are representing people, I've been there, counsel. I understand that when people are representing people, sometimes we get overzealous. Maybe we forget the rules. But this is the last time I'm going to say this. Number one, my rulings are my rulings. You made your objection. I have answered that objection. There's to be none of this going back saying, well, Judge, you're wrong because of A, B, C, and D. If you think I'm wrong in my ruling, that's where you appeal it, the end. There's not going to be any sidebar comments. And I told both parties yesterday, we're not doing sidebar comments because then you get into areas that you're not supposed to get in. We're not doing mock trial. This is not where we do sidebar comments to get something before a jury that it shouldn't be before them. Legal objections only. All right. Now, next, while the jury is out, stay. If you want to approach with the defense so you can see what he wants to show the witness. All right, let's do the MTR.
Just so I don't have to object. You see that?
All right.
The examiner?
Yeah.
All right, thank you.
It's a-
So if you could
Okay.
bring them in.
Straight up. and-
I will.
Okay.
It's the one with a base. That's it.
Okay.
Okay. The one.
I'll take it.
That's all right with Bob.
Yeah, so, no, you guys have.
I'll take it to Paris.
When we first got out here.
All right, if you want to step down from the witness stand and you all can do that at the back, I'm about to take up a motion to revoke. Yes.
You actually go into.
Do you need to watch the whole thing or do you think? I asked you?
Could you have IT come down and let them know that none of this equipment is working?
You actually have to go further off, so we started going, you're swimming. While we were swimming. From the stairs, maybe 5-6 feet.
I do have a question directly related to these proceedings.
Yes.
I guess we have to use this. I'm just gonna ask you to put on a headphone.
Let's say, I asked my question. Defense counsel objects. Say sustained. I believe that I have
An exception.
an exception.
Right, and you just say, Your Honor, may I be heard? I have an exception.
Okay, so in that instance, if I say, Your Honor, I believe I have an exception and I've heard
Yes,
that's acceptable.
yes, and I will let you be heard.
Understood.
All right, thank you.
Clarify.
Sure, no
Can I
problem.
get that instruction also?
Instruction for everybody, but it's all legal objections.
I understand, but.
All right.
But I have to be able to make my record. And so.
Let me just tell
Pardon
you,
me.
your record is not,
That's okay.
Judge, you're wrong. That's not a record. The
No.
record is
Are we- are
objection,
we on the record
hearsay.
right now?
No, we're not. The objection is hearsay. I
know.
will sustain the objection. And then guess what? If the state has an exception to that, then I will hear it. If the state objects to hearsay, and if you have an exception to that, I will hear that. But I'm not hearing sidebar comments. I'm not hearing I'm not hearing objections that are not legal objections. All right. So are y'all ready on Valero?
Yes, Your Honor.
All right.
In the back. We're ready. Moreno, they're swearing him right now.
All right. Once they swear them in, we'll take that up.
Thank you.
All right.
Just.
That was working for the-
I need to have a piece of evidence that it was there in order's custody. And so would it be okay with the court if we have the witness fill out the property receipt while.
Yes.
jury's out? Could
Yes.
just save time.
Yes.
They're on their way.
All right. Thank you.
So what did you tell me?
Basically, what she just stated to all three of us,
All right.
give her the scenario. I ask a witness a question, defense counsel objects.
Oh, we gotta wait,
we
gotta wait.
No. If they sworn him in, we can
I
take
think
him
I
because
have
the
an
other
exception.
person is not.
May I present?
Not on his way.
She
Yeah.
said, yes. If you say,
All right.
Your Honor, I believe there was an exception. Will you allow me to explain it? You won't give me that opportunity.
It's a hectic day today.
More paper here than buying a house.
Well,
I guess you're signing for the big house. Maybe.
Sometimes it's not a matter.
Amazing how much paperwork.
All right, we're gonna go on the record. Court is calling 2024 CR 0100059 State versus Jesse Moreno. Can I have parties announced? State?
Jason, do you have to say?
Cody Bartolome on behalf of Mr. Moreno. Mr. Moreno on bond, present, ready for plea, Judge.
All right, and you, Mr. Moreno?
No.
All right, you need to make sure you speak up.
Sorry.
Counsel, have you received all discovery?
I have, Your Honor.
Did you review it with your client?
We have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Moreno, did you review the document entitled Application for Deferred Adjudication with your attorney? Did you understand it?
Yes, ma'am.
Did you sign it?
That's fine, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Just possession of over 400 to make it up to 99.
All right, did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorney?
I did, Your Honor.
Did you understand it and sign it in all the appropriate places? All right, the state is proceeding on the lesser included offense of possession of a controlled substance penalty group 1 over 400 grams. Range of punishment is 10 years to 99 years or life in prison and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights? Did you intend to give up those rights and enter into a plea in this case? Did you intend to
no.
give up those rights and enter into a plea bargain agreement in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could sentence you up to life in prison and up to a $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
As to both, yes, Your Honor.
Mr. Moreno, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
Mm,
Anyone promised you anything other than the plea?
mm,
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, the state is proceeding on the lesser included offense, recommendation of deferred adjudication. They're taking in consideration AL 2150458. Did you understand that to be the plea? Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
It is.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there any such motions?
There have been none at this time heard or ruled on, Judge.
Outside the agreement, the state is requesting that your community supervision be for a term of 6 years. There be a TAP evaluation and drug offender education program and regular UAs. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? Then to the offenses charged, the lesser included offenses charged, how do you plea?
No contest.
State any evidence.
You've reviewed the documents and the drug test, Judge. No objection.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you applied for deferred adjudication. Are we proceeding with sentencing?
We are, Your Honor.
All right, and there's a reason for this offer, I'm assuming?
Judge,
All right. So why should I follow this?
Well, first of all, Your Honor, my client obviously has made a serious mistake, Judge, and he's very contrite. I've known,
Choice.
well, Judge,
Not a mistake, choices.
amen, Judge. I'll use the word choice.
All right, thank you.
A poor choice, Judge, if I may qualify that. Secondly, and more importantly, Your Honor, I've counseled with him long and hard. I've known his family for a number of years. He has support, Your Honor, of his family. He understands the risk. He understands the significance of a 99 to life possibility, Judge. And he understands the responsibilities that are necessary to demonstrate to this court that he can and will become a productive citizen, Judge. I'm going to ask the court to follow the 6 years deferred. He has employment and he is capable, Your Honor, and I can assure you he is exceptionally nervous, Judge, at this point in time. But I believe with his family, and we visited long and hard about this on at least 3 occasions for over an hour, Judge, I would ask that the court follow the agreement, place him on deferred for 6 years, Your Honor, with conditions the court would deem appropriate. And with that, Your Honor, I defer to the court.
All right, what do you do for a living?
I do construction concrete.
And how old are you?
I'm 24.
Do you have any children?
I'm not.
All right, this is what the court is going to do. Court is going to sentence you to 10 years deferred adjudication, 90 days in the Bexar County Jail as a condition of probation. That's to start today. TAP evaluation to take place in custody. Follow TAP recommendations, regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days of release, no employment as a home health care provider or minors. There's to be GPS upon release, waive fees, and it will be partial GPS for employment only. 200 hours of community service restitution. Take in consideration AL 21505. I'm sorry, AL 2150458. Probation, and I'm going to want field visits 1 time per month for 6 months. Probation, is there anything else? Is there anything else that you need from the court to be successful?
Can you speak up and say something?
No.
Can I talk to him though, Judge, before you take him in the back?
Just 1 second. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal? Did you review that with your attorney? Did you understand it and sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, good luck to you.
May I speak to him before they take him back?
You can speak to him that way because we have jurists.
I thought that, Judge. I just wanted to be safe.
Just 1 second. Excuse me, who are you? All right, and who is this? All right, so let me just tell you something. Do you know how many people die every day because somebody is selling drugs to them? A lot. He could be going to prison for 10 years. He is not. He is going to the Bexar County Jail. He's been given probation. Other people who have used drugs that maybe he sold to them or that somebody else sold to them, you know where they are? They're dead because somebody is preying upon their weakness and somebody has gotten them addicted to drugs. So if there are tears, there should be tears for the people who have died because somebody sold drugs to him. He's not going to prison. He's at the Bexar County Jail. He will be given probation. So if there are tears, cry for the people who have been found in the field, OD'd, got some bad drugs, for the people who are trying to be clean and sober, but there's some dealer out there who keeps coming up to them and saying, just try it, just only one time, because they are building their happiness off someone else's misery. Yes. All right, thank you.
Say something to you
No,
as well?
no. All right, the court is calling 2024 CR 1726, State of Texas versus Rogelio Valero Jr. Can I have parties announced for the record for the state?
Jason Gary, Your Honor.
Defense?
Will Brooks, Judge.
Are you Mr. Valero?
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Rogelio Valero Jr. who was placed on deferred adjudication
Hold them.
and cause number 2024 CR 1726 for the offense of possession of a controlled substance, penalty group 1, 4,200 grams on June 6, 2024 for a period of 5 years? Is that you?
Yes.
All right, state.
Yes, Your Honor. Following condition number 1, on or about the 29th day of October 2024, Fair County, Texas, Defendant Rio Valero Jr. Convicted of possession of controlled substance, penalty group 1, in violation of condition.
How do you plead to that? True or not true?
True.
Any objections?
No objections, Judge.
All right, did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in prison and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 1?
Yes.
Court will find violation of condition number 1 true. Is there a proposed agreement?
It's under me, Your Honor.
All right, state, what are you requesting?
The state is requesting revocation, Your Honor, and since the individual did plead true to the number 1, state would be taking into consideration that case. That is cause number 2024 PF 21614.
And with regards to the case that's being taken in consideration, do you have an amount?
It was from 1 to 4. That's what it's charged as. We haven't got the wires back yet, so it quite possibly could go below 1.
All right, and defense, what are you requesting?
Judge, I'm asking the court to order Valero into treatment, and I can give the court an explanation as to why.
Yes.
So Mr. Valero started using methamphetamine in 2020, Judge, when he lost his mother. The drug has taken a lot from him, taken his family from him, taken work, friends. He has continued to use, Judge, up until he was incarcerated for this particular offense, both by admission and by positive test. He is an addict, Your Honor, and he is appearing for you in front of you today, asking you for some help. He's ready to make a change in his life. Unlike many clients that I have, Your Honor, who tell me, no, I don't want, they want the Burger King. They want treatment and they want it their way. He was very forthright about the fact that he needs and wants some help. He has not ever been to inpatient treatment, Judge. He's 51 years old. This is the most significant trouble this gentleman has ever been in. There was an updated TAP evaluation, which actually, I'm sorry, there was a TAP performed, which is the first time it had been done, even though it had been ordered while he's been in jail. And that TAP recommended that he be sent to the substance abuse treatment facility if the court should consider that modality of treatment. And I invite the court to talk to Mr. Valero if the court has questions, but I found him to be pretty earnest and honest about his usage. There was no excuses, nothing offered to try and shade it his way, if that makes sense.
All right. Mr.
If I may too, I'm so sorry, the last thing.
Yes.
This is the longest that he has been sober since that period of time. He's been in since October, but that's his longest period of not using methamphetamine. He started that usage in
All right,
2020.
this is what the court is going to do. And the court realizes that sometimes there's a big difference between possession with intent to deliver and possession. Now, if you would have had a chance to use the drugs, then you would not have been charged with possession. And based upon what the state has told me about what they anticipate the level of felony may be and the amount of drugs, it appears to the court that there is a drug issue with you and not an issue of your being on probation and selling drugs. So this is what the court will do. I'll deny the motion. Take in consideration 2024 PF 21614, alternate amend conditions to include inpatient treatment, follow the TEP recommendations. And also, I know that felony drug court said no more referrals until, when is it, Mr. Brooks?
Well, we're down a case manager right now, Miss McKenzie, and so she's on maternity leave, which started 3 weeks ago or so.
What we'll do then, Ms. Abrams, after inpatient treatment, do a referral to felony drug court. There is to be partial GPS, waive the fees, and that partial GPS is to be upon release from inpatient treatment. And he's allowed to have employment and of course, go to treatment appointments. Probation, is there anything else?
No, man.
Is there anything else you need from the court to continue being sober?
I appreciate your help and I'm sorry for all I have done wrong. And thank you very much.
All right, you're welcome. We can go off the record in this court to be successful in probation. Communication is key. You can't do this thing where you go on a bender and then you don't report. If you think you're going to use, then you need to make sure that you have a sponsor or someone you can call. You understand?
Yes, ma'am.
All right. And also, Ms. Abrams, we'll add 90 sober meetings in 90 days upon release. All right. Thank you. Right. And did IT leave or there?
Yes, they need to disconnect the server to get us
Okay.
back on. Is that okay?
No, that's not a problem. State and defense, on this case, are you all going to be admitting things into evidence that requires IT?
Send me an email to them.
The video, for example?
I mean, I would like to.
All right. Well, no, it's either yes or no questions. All right. Then what I'm going to do, if there's no objections, I'm going to go ahead and send the jurors on their lunch break early.
Andrew.
And the reason why I'm doing that is because IT is here and the only way they can perhaps fix the equipment is to shut things down. So any objections?
No objection, Your Honor.
All right, any objection to the court letting the jurors know that they're going to be going on lunch break early? And I'll let them know it's an IT issue, not